Hello and welcome to this episode of On the Neutral Ground. And thanks for tuning in.
And check us out on all social media platforms at On the NG Show, as well as YouTube and Apple Podcasts.
Hi, I'm Victoria Green.
And I'm Jason Wagenspeck. Today, we're going to talk about the legal side of the film industry, the pitfalls, the mistakes that can be made. It's probably important to hire a lawyer.
It's very important. And our guests are Max Haas and Murray Roth, and they give us quite a bit of information. You know, in filmmaking, having the right legal team is so very important.
Absolutely. This is going to be a great show.
Enjoy the show.
But guys, welcome to the show. Thank you for being here today.
Thanks for having us.
Absolutely.
Yeah, great.
Max and Murray, we're thrilled to have you here. Before we get started talking about entertainment law, why don't you both tell us a little something about yourself? Murray, why don't you go first?
Okay. Well, I'm born and raised in the New Orleans area. I went to LSU for my undergrad, and then I went to law school at Loyola.
Go Tigers.
Go Tigers for sure.
Sorry.
I've been practicing law in Louisiana the entire time.
Mm-hmm.
I've been a lawyer for over 20 years now. Most of the beginning time of my practice was I've practiced in all areas of the law, lots of litigation. But I guess it was right around 2002 when they passed the tax credit law here that I started getting interested in entertainment law, and I started studying it and developing a specialty, realizing that it looked like there was a new industry coming. So I did that for many years. And then after Katrina, in addition to being a lawyer, I started wanting to be a producer also. And I guess it was around 2010 that I actually started expanding to where I was doing legal entertainment work, mainly for independent filmmakers here in Louisiana. And then I started doing producing too, and then I've been doing it ever since.
So that's primarily your work now?
Well, I still have a lot of business clients that are unrelated to film.
Okay.
But it's a combination of business clients and entertainment law clients, mainly people working in the independent realm of the film, from anywhere from ultra low budget to seven figures.
Absolutely.
Max, tell us a little bit about your background and how you got into entertainment law.
Sure. So I'm originally from upstate New York, but I came down to New Orleans to attend law school at Tulane. I had been a musician since I was about 10 years old and wanted to find a way to get even more involved in the arts, not only as a performer and writer, but also to help empower other artists to help get their projects off the ground. While I was in law school, I interned with the Ella Project, where I was introduced to a number of musicians and filmmakers and other artists who had legal issues, and started to recognize pretty early on how there's a bit of a sort of mismatch between the availability of legal services for creative people in this town and the creative activity that's going on here. We have really only a handful of lawyers available, but literally thousands of creative people who have projects going on. And so after law school, I worked as a manager for a local musician, took on a few other clients around that time as well, and then expanded into work as a booking agent and a promoter. And then in late 2017, I started my own entertainment law practice where I serve musicians, filmmakers, writers, designers, kind of across the spectrum of arts and entertainment-related fields.
And we met at the film festival. You were volunteering. I think that was in 2015 or 2016.
Yeah, and I volunteered with the film festival a few years before that as well. So I was a part of the film festival in a very small way for probably about 3 or 4 years.
Great. Well, we obviously on this podcast love to bring on experts in the field, and you guys sound like you should be perfect for this this podcast, obviously, for the fact that we want to see young budding filmmakers find the resources they need to continue to tell as many of the stories or create as many of the projects as possible. So let's just take it from the top, or I should say from the ground. What is it that a young or budding filmmaker needs to know legally to get started if they're creating a project? They have an idea, they're either doing it solo or doing it with a partner. And what is it they should start off with from the onset before they get into any form of production? Murray, you want to start with that?
Yeah. So, well, first off, it depends if they have a script or not.
Okay.
Okay, if they've written, the filmmaker has written the script, that's going to be different than if they're going out to go acquire a script or hire someone to write a script. So I guess we'll start from the very beginning. Let's assume that they don't have a script. At that point, at some point, they're going to have to start an LLC to control the production. It's not always necessary that you do it at that stage. And the reason for that is sometimes, development can take so long that when you start incurring expenses for the LLC that's going to apply for the tax credits, you might not want to do it just right away. You might want to do it as an individual, or you could start an LLC, which is not a big task to do. But we'll get into that in a minute. But the first thing you want to do is you want to hire the writer. Now, either you're going to hire the writer to write the script, or you're going to purchase a script from someone. If you're going to hire the writer, the first thing you need to do is you need to have a writer's contract that has a lot of special magic language in it. It's not just a contract that says, I'm going to pay you this much. It's got to be what's called a work for hire. And under the copyright law, because that's what you're worried about at this point as a filmmaker, you want to ensure that this script that is being written for you, that you're paying someone, assuming, to write, that the filmmaker is going to own the copyright to the script when it's done. And if you don't have that work for hire writer agreement, then the writer technically will own the script. So under the copyright law, I mean, we could talk about this for a long time. I'm going to kind of speed through it.
Okay.
But under the copyright law, a person who writes, or not just a script, but creates music, or any way that they take an artwork and put it into a tangible form, as they say. So when you actually write it down, well, you hear often about ideas are not protected. You got to have that idea, and it's got to be written like into a treatment or written into the script. Under the copyright law in the United States since 1978, you automatically own, whoever that person is, you automatically own the copyright to that. Even before you register with the Copyright Office, which is done for a different reason, you literally own that work right there in front of you. You could write a poem right here. And as soon as you're finished it, you own the copyright to that.
Even without registering it through the Library of Congress.
Right. The minute it takes that tangible form is when the copyright begins.
And so I have a quick question while you continue. Should that person email it to themselves? Is that one sort of legal way I've heard in the past that really says this is yours, versus you writing it down and somebody picks it up and then takes it off on his own?
You would have?
I've gotten that question lots of times, and ultimately all that's really doing is establishing some evidence. So it can be helpful if you get into some sort of dispute later, because then you have that timestamp that shows that the script existed at least as of the date that you emailed it to yourself. You've probably heard of the pre-email version of that called the poor man's copyright, where someone puts it in an envelope and mails it to themselves. Yep. And by having that third-party independent verification of the date, i.e. the postmark that's given by the post office, you have that date. And as long as the letter remains sealed, then it's you can demonstrate it hasn't been tampered with, and therefore it must have existed at that time. The thing is, that's still not a copyright registration. It doesn't get you the benefits the copyright registration has. And with respect to when the copyright begins, your rights began the minute you finished the script, not the minute you put it in the mail. So you're really not giving yourself anything extra other than, like I said, that, pretty useful evidence. So because that script, your rights in that script existed the moment you finished writing it, by putting it in the mail or emailing it to yourself, all you're doing is, like I said, creating that piece of evidence. It can be useful evidence if you get into disputes with somebody who claims that they're actually the writer of the script and not someone else, and you can prove, at least the date that it was associated with your name, but it doesn't prove who actually created it, so it only gets you so far.
So at what point do you register it with the Library of Congress? Register your work?
When it's completed, obviously.
Okay.
But getting back to what I was saying is that the person who creates it, with nobody else involved, you are the legal author of this. A lot of people get that word confused because it's a legal term. It's not necessarily who actually penned the script. Because when you have a work for hire contract with a writer, the filmmaker does, even though the writer is the one that literally authored the script, the filmmaker is the legal author under the law. They own it. And they are the person who is entitled to register the script with the Copyright Office. And when they ask the question, who is the author, the filmmaker gets to put their name there. Usually it's a production company. But they are the legal author. So that's the first thing you're going to do is get that contract with the writer with a work for hire agreement. And then there's a lot of other technical stuff that needs to go in there.
But essentially, contract, when you're starting a film, whether you're the writer yourself and going to direct it, or you're hiring a writer, regardless, get a contract, number one, first and foremost, correct?
I am the biggest proponent of getting everything signed up front, and not just with a chain of title stuff like we're talking about now, but I mean everything. Like don't ever film on a location before you get that location agreement signed. For some reason, it's just human nature that after you're done, suddenly that location owner feels that they're entitled to something more. And it's just, I'm across the board. You get everything signed up front. Okay.
I second that.
Yeah.
100%.
It makes your life
that.
so much easier later. And before you start filming is when everybody's happy, everybody's in a
Your
good
friends.
mood, everybody's getting along.
Right.
Yeah.
It's the best time to sign the contracts.
Well,
okay.
Yeah, my good friend and obviously compadre here at the ranch, Jimmy Hornbeek, taught me very early on, you make your deals up front. So you just need to sit down, you need to hash out early on, even if it's a simple conversation, so that you all have that open communication on what is it our expectations are moving forward. And obviously hiring legal representation to help you in that is extremely useful, because you're not going to understand what you could potentially be getting into in the future if this thing decides to take off and hopefully make you $1 million, So you want to have that up front.
Exactly. I'll say one more thing, and I'll turn it over to Max for assignments. But it's not just signing a contract. There's certain magic language that have to be in these contracts. It's not just, I'm going to pay you so much money to write this script for me. So you don't, this is the first, the most important contract you're going to do is with the production, the filmmaker and the writer. So you want to make sure that that it is done by an attorney, because that's a really important one. Yep. The other way to acquire a script is if a script already exists, somebody's already written it, and you have to get it by an assignment. I'll let you explain that.
Well, before
Sure.
you answer that question,
Okay.
there's a lot of information online. Work for hire contracts. Can a filmmaker just go online, or should they consult with an attorney?
And find a work for hire contract online and just use that. There are definitely a lot of template contracts out there. It's certainly not a bad place to start, but I would say that's all it is a start. You could then take that template you found online and bring it to your attorney and say, hey, does this look good? Does this do what I want it to do? And then they can always make some modifications to it. As Murray said, for the work for hire doctrine to apply, you have to have specific language in the contract that says this is a work made for hire under the U.S. copyright law. Sometimes contracts go even further and give you the citation to the statute and all that other stuff, which isn't entirely necessary. But there is a very famous Supreme Court case that made it explicitly clear that when you have somebody who's an independent contractor and not an employee, in order for work for hire to apply, you must have a written agreement that explicitly states that the work is made for hire. And in most situations, your writer, at a minimum, is going to be an independent contractor. Even if you have other people as part of the production later on who are treated more like employees, like you have them sign W-2s and you give them weekly paychecks instead of a one-off payment or invoice-based compensation, things like that. When you're dealing with an independent contractor, the words work made for hire are crucial to have in there. Now, the other thing with that, and this isn't really an issue here because we're talking about film, but the work for hire doctrine also only applies to 9 categories of works. One of those is films and motion pictures. The others are things like instructional material, tests, and other things. And interestingly, music, sound recordings, and visual art are not included on that. So the work for hire concept, because it's so prevalent in film, has sort of expanded in the sort of public consciousness. And a lot of artists that I've met who are not in the film world think that, work for hire applies the same way, or they work with somebody who thinks that work for hire works the same way. It actually doesn't. But a lot of people still put those contracts in place anyway. And there's sort of this understanding that what they mean is for the work for hire doctrine to apply, and hopefully nobody makes a fuss about it and it's all fine and good. But when a work is not a work made for hire, either it's not in one of the 9 categories, or the person you're hiring is an employee, or is, I guess, if they are an employee, it can be a work for hire even without a contract. But if they're an independent contractor and you don't have that contract in place, then you can't transfer that authorship aspect of it that Murray talked about a few minutes ago. The most that you can do is simply transfer ownership of the copyrights. So the person who literally penned the script will still have to be considered the author of the work, but there are legal mechanisms available, notably the assignment of copyright, that allow the ownership of the rights to transfer. Copyright is a piece of property, and so it can be bought and sold and transferred just like a physical piece of property can, and that's what an assignment is a sale, essentially.
Very interesting.
I have a question regarding something a little bit more in depth. And these are questions that came to me. I put a post on Facebook, hey, we're going to be meeting with some attorneys. Do you guys have any questions? And there were a couple of questions that came up. And one, a writer-director hires a producer who funds the movie and pays for everything. And that writer-director does not have a contract with the producer. Who owns the film if no contract is made between these two individuals?
It depends.
Classic lawyer's answer, but
it's going to get into who contributed how much to.
The writer-director didn't spend any money, but there was no contract.
But it's not always.
But the writer-director
wrote the
is the one
script.
that's shooting the camera and is capturing all the footage, and then you want to know how much did the producer play in that role in actually making the movie. Was the producer just off in an office somewhere and just put up the money?
The check, yeah.
You want to?
Yeah, so there is a doctrine created by case law called the dominant author test, and it's been modified somewhat recently, though not by the Supreme Court. So the applicability of this test varies depending on which federal circuit you're in. But often most attorneys in the entertainment business follow what either the Second Circuit in New York or the Ninth Circuit in San Francisco says about these types of issues, because those are the courts that deal with entertainment-related copyright issues vast majority of the time, with maybe the Fifth Circuit far behind them and the rest of the circuits even farther behind that. But the dominant author test essentially says that you have to look at, like Murray was saying, who contributed what and who was sort of the steward of the work. Now, additionally, if you go to the Copyright Office in their FAQ section, they also have these documents called circulars that are these 3 to 5 page PDFs that explain just one topic at a time. So there's a lot of information on the Copyright Office website. And in those FAQs, one of the things that you can find is basically the types of people who are typically considered authors of a audiovisual work, which is what motion pictures fall under. And typically that's limited to the producer, director, writer, editor, and
VP?
There is a fifth, yes, cinematographer, yeah. So that means that usually actors don't have a claim of authorship, even if they're the ones coming up with the way they want to deliver the line and all of that. And then courts take that a step further. Whenever there's a dispute, they really look at all of these different factual considerations, and they look and they say, okay, who was actually in control of this project? And that's ultimately what dictates it. So with a writer-director, like Murray was saying, who wrote the script, who was on set every day, directing, capturing all the footage, the producer is maybe in a distant office somewhere. Ultimately, the expenditure of money is only one factor, and frankly, not even the most important one when courts look at this. They look at who actually created the work, because that's ultimately what copyright is about, is an expression of an idea, not who financed the expression of the idea, but who created that particular expression.
Yeah, it would be decided on a case-by-case basis, those types of things, which is all the more reason why you need to have contracts in place for all of this.
That's almost as important as networking, right?
Absolutely. And, it's funny, a lot of people are very nervous about the expense of lawyers. And I've come to find out overall, it's not as expensive as you think. And a lot of you all are, pretty reasonable and willing to work with a lot of young, independent, budding filmmakers. And so I definitely recommend that they all at least reach out, especially to the two of you from our podcast and other lawyers, just to have a conversation about that so that they can get those things and those steps in the process early on.
Yeah, and I just wanted to add that question also highlights an important point, which is that in any given film, there are multiple different copyrights involved. So you have a copyright in the script, but then you also have a copyright in the finished film. It's a totally different type of work. The Copyright Office recognizes certain categories of works. The script is considered a work of performing arts, whereas the film is considered an audiovisual work. And so that's just a simple categorical distinction, but it has a lot of implications because it shows you that the script and the copyright to that script could have been created under very different circumstances than the film itself. And there's a different creator of that work. The writer is not necessarily the director or the producer. And then the finished film might not even involve the writer much at all. And so you have totally different authors who are creating the film. And so, it all kind of circles back around and highlights the importance of these contracts, because getting a script in place for the writer is only a first step, but then you also have a lot of other people you bring on board later, and that work for hire doctrine applies through all of it as a motion picture, and you have to be very careful to make sure that pretty much everybody who's on board with this film is signing a contract that contains a work for hire clause, so that whoever the primary person who's in control of the work, whether that's the producer or the director or whoever is really sort of leading the project, the goal when we consult clients is to make sure that that person has as close to 100% control of the project as possible. And so that necessarily means getting those work for hire agreements in place with everybody involved.
Oh, yeah. Crew deal memos, cast contracts, you've got SAG involved. Sometimes if you're large enough, you'll have IATSE involved, DGA. There's quite a bit that needs to be handled, and it's over one person's head, obviously. So,
and let me just say this: it's not just important to have these contracts for the producer to protect liability and so forth. You're going to have to produce all of these to a distributor.
Correct.
Down the road. Their lawyers are going to go through your contracts because they are deriving their rights and protections from the contracts that you sign with everyone on that film. And they are going to demand that all that language was in these contracts. And if you can't produce that, you're going to have a problem.
Yeah.
One of the reasons this is so important comes from some of the default provisions in the copyright statute that basically says that if you have multiple collaborators on a project and they have the subjective intent to merge their talents into one work, which is typically what's happening in a collaboration, then the result is they are co-authors of that work and therefore co-owners. And when you are co-owners of a work, just like co-owners of real property, of immovable property in Louisiana, you are allowed as a co-owner to issue licenses and to make money off of that without getting permission of your other co-owner in many situations.
Really?
There's certain limitations. You can't issue exclusive licenses and you can't issue an assignment of the entire copyright. But when you have the possibility of co-owners who didn't sign a work for hire or an assignment contract, the distributors are going to look at that and they're going to say, let's get that tightened up, because we don't want to strike a deal with this one person here who's sitting at the table with us and then find out 2 years from now that there's another co-owner who never wanted a distribution deal, and now they're suing the distributor for either infringement or accounting of royalties or other issues. And so it's kind of an interesting dynamic, because the default rules are meant to essentially protect creators on a very basic level. But as a project moves forward and you start monetizing it and you start getting serious about really doing something with it on a commercial level, those default rules can really work against you. If you don't have those contracts in place, it gives your co-owner a lot of power to sort of intervene in those issues.
So based on what you just said, there's two film students. They work on a script together. They get they don't get a contract, and they both own the script because they don't have a contract. They have a falling out. Essentially, one can make one movie about the script, and then the other person can make their own movie as well. Is that correct?
Yes, it is. The film is considered a derivative work based on the script. So in every copyright, you have a set of 5 core rights, and one of them is the right to authorize derivative works. A derivative work is basically just a new copyrighted work that's based on an original work. And so with almost every film, the original work is the script. And that's why Murray pointed that out at the beginning, is because that's where everything flows from. And so if you're co-owners of that copyright, you both have the right to authorize derivative works. And so you could each go off and make your own adaptation of the script based on the rights that each of those co-owners has.
And let me add, but what will happen is the distributor's not going to touch either of those films.
Of course.
Because they realize the liability. And in addition to the contract you may have with the writer, the distributor is going to make you sign all types of indemnification clauses and certificates of authorship where you're swearing under oath that you're the only person that wrote the script and there's nobody else out there. And if it ever comes out to show that was not the truth, then the distributor is going to be coming back after you. So technically what you say is correct, but in reality, there are a lot of safeguards that distributors are going to take to try to make sure that doesn't happen.
In the realm of self-distribution with TVOD and VOD, I feel like I'm seeing less and less of that. It's always going to be an issue, but of proof of those contracts in place for distribution. You're putting stuff on Amazon, you're putting stuff on iTunes. I don't see as much of that being checked off. Do you?
No, I don't know the specifics of the particular law that's explained here today, but there is law dealing with these online
would be.
Where they can be, even though they're screening something that belongs to someone else, as long as they don't have any firsthand knowledge that it's infringing on somebody else's copyright, they can't necessarily get in any trouble until they get notice.
Yeah.
So what will happen is the streamers, you're right, like iTunes, Amazon, Google Play, they don't require all of this stuff from you. I think you might have to sign some representation form, but once somebody who claims that this movie is infringing their copyright, they send notice to iTunes, then suddenly they're going to take your movie down until the whole dispute is resolved. And as long as they do that, they can't necessarily get in trouble for it.
And you're probably in a lot more trouble in that point than you would be from the previous, which is not getting distribution. So, I mean, I would hate to go down that road as well. But something I noticed, like I said, we submitted a couple projects. They haven't asked for much paperwork. And so here we are with, a couple of online series. But we're all booked up, thankfully, because we had great legal representation in the beginning. But
what about DVDs? Is that the same concept as far as making sure all of the copyrights and all of the contracts are signed? The same deliverables with DVD productions if you're doing them yourself versus VOD?
If you're doing it yourself,
well, not yourself, but you're hiring a company to make the master and then produce the DVDs.
They would probably, and I'm speaking from my experience in music, because there's lots of musicians who are doing self-production of, they go to CD Baby or Disc Makers or one of those other companies, and they just get 1,000 CDs made and they have them shipped back to themselves. I know in that scenario, a company like Disc Makers will have you sign something or check a box, something, the digital or online equivalent of signing a representation that you own the rights. But that's as much as I've seen. You don't really have like a detailed negotiation with a DVD production company every time you want to get a project made. They really just treat their services as a service. You come to us with your own work, your own project, we'll run off the DVDs for you and you get them back, and then it's up to you how you want to sell them. When you start getting into actual distribution deals is where they want to see that clear chain of title.
Yeah, a company that's just making DVDs for you is going to be different than a company that is a DVD distributor. They're going to be much more strict about your chain of title, and that's what this is called. It's producers out there know that term.
Correct.
Distributors want to see a solid chain of title to the ownership of the movie, and that's all of these documents that we're talking about right now encompass what's known as the chain of title. And it's almost similar to like when you buy a piece of real estate. And, you have these extensive researches in the public records to make sure that there's no defects in the title to the property. And your chain of title to your movie is really very similar. And the distributors, they have their own methods of trying to get this information out of you and holding it on you if you don't give them and show them everything that they need.
When I started my first project, which was a feature film, like who does that, right? Your first film is a feature film and a doc. I couldn't afford an attorney. I mean, I learned a lot more. I probably would never have created the same type of project if I knew then what I know now. But you talked a little bit, Max, about the Ella project through Tulane. And that's what I did qualify. And I had some attorneys through the Tulane Law School representing me in the beginning, but I've had several attorneys since then. How has that program benefited the musicians and the filmmakers that maybe have short films or don't have the money?
Yeah, that's a great question. I don't I don't work for the Ella Project today or anything like that, but I have worked with them quite a bit over the years. Most recently partnered with them to put on a series of educational workshops on exactly these issues, copyright and contract as it applies to creative individuals. And essentially what the Ella Project provides are two distinct services. One, and the most important, being direct legal consulting and legal services. And essentially they have one supervising attorney who works with law student interns at Tulane. They have their sessions every Friday. And basically you have to, submit an application form to just get into their database. But then once you've done that, I think it's a pretty small application fee of $25 or $35 or something like that. Then it's just a matter of scheduling, and you say, I'd like to come in for a consultation. When's your next availability? It's usually no more than a 2 to 3 week lead time, and you go in, you have about an hour. The attorney there talks through what you have going on. And then frequently they can actually provide ongoing assistance in the form of drafting contracts and getting some basic things set up for you. And then additionally, the Ella Project as a nonprofit organization also sponsors workshops like the one that I put on. They also travel around the state of Louisiana, putting on their own workshops, working with government and other municipalities to figure out ways to improve arts and culture related policy. So they're doing a lot to really advocate for artists and creators in a lot of different ways. And the important thing about those direct legal services I mentioned, the consultations and whatnot, that's all free. Once you've paid the application fee, it's all pro bono. And so, you do have to meet certain income requirements, which is to say you can't make too much money. Otherwise you won't qualify for pro bono. But as long as you pass that, then you're able to go in and get legal help. So it's a really great resource, and I'm constantly coming across people who haven't heard of it, and I spread the word about it as much as I can.
Can you tell us where they can find more information about this? Is there a website for it?
Their website, I believe, is ellanola.org, ELLANOLA.org. And their offices are on Frenchman Street above Louisiana Music Factory. They share space with Offbeat Magazine.
That's great.
So
Good
really
information.
easy to find, very accessible location. And they're there every Friday.
That's awesome.
For the clinics, the staff are there all week. But
So no one should have an excuse not to have a contract. So for that filmmaker that is in college or very young or doing a short, that is an area that's available to you. But as Jason mentioned a few moments ago, you guys, you gentlemen, as well as other attorneys involved in the film community, you're going to have work with the filmmakers. I mean, we need an attorney for more than just contracts, but you're going to work with us. It's not a one price fits all, right?
It usually, with what I do, it's usually going to be based upon what the budget of the film is. So, the legal has to be budgeted into the movie. It's not something, if you're going to make a short film, sure, you're going to need contracts for certain things. But when you're making a feature length movie that's going to be commercially sold and commercially submitted to distributors, there's a whole slew of legal that needs to be done. And if you don't have that done correctly, distributors just aren't going to touch your film. There's too much liability associated with that. So it really needs to be budgeted into the film of what the legal will be. And I've worked on many different budgets. It is a lot of work, even when you have someone doing a really ultra low budget movie. There's a lot of, you got to do the same legal for that just as much as you have to do for the $1.5 million movie. And it's basically the same thing, but it's absolutely vital to have if you want to be able to sell that movie down the road. So it's not something that should ever be overlooked. And, and again, I usually work with filmmakers within their budgets and, depends on the situation, but I'm always making sure that they have the most important things in place from the beginning.
So just like a sound design, you need to upfront when you're creating a budget, put that budget in your film for legal fees.
Yeah, and I don't know if this normally shows up as a separate line item or not, but related to the legal fees as you're going to pay your attorney to do that work, you're also going to have clearance fees that you'll have to pay as part of that legal process. One of the things I think we'll be talking about a little bit later is getting music into your film. If you have a full soundtrack worth of music in your feature-length film, you're going to be paying licensing fees to get that music into your film. If you're getting a location agreement in place, the property owner might want a location fee. And so all of that stuff, even though it might, and I'm not a producer, so I don't know exactly how budgets are put together, but that's sort of, if not part of your legal line item, it's certainly very closely related, because as your attorney is working on all of these various aspects of your project, making sure that you can get things cleared well ahead of the time that you need them to be cleared is really important. So having the money budgeted for to be able to spend a couple thousand to get that one song you really want in the film is definitely an important thing to be thinking about as well. I've met so many people who don't think about clearance until their project is done and ready to be distributed. And I'm not trying to call anybody out here. I've got lots of other people who I've had this experience with. It happens in music too, when people have samples and other things. They just don't tend to think about budgeting for clearance, and not only budgeting financially, but also budgeting time-wise. It takes a couple weeks or a couple months sometimes to negotiate clearances in a film. So.
And I mean, nowadays, even if you put something up on YouTube, you're finding that Google, that is marking some of the music, for instance, that's not been cleared, and will pull that video down immediately. I remember back in the day when we were doing videos and we just had some local musicians and we loved some of the work they did. And so we were just making quick little videos and putting them up on YouTube, and nobody really said anything. And about a year later, all of a sudden we started noticing those were starting to get taken down. We were like, what's going on? I mean, we just created this fun little 1 minute thing with a little snippet of music, but hey, at the end of the day, we didn't get the clearance from that musician. We learned an early lesson on what it takes to really kind of go down that road.
Right, and that's another thing that distributors are going to look for, maybe not technically part of the chain of title, but certainly a really important liability that distributors want to make sure they're protected against, is that all of the music that appears in the film is cleared.
Yep.
Because the distributors often are going to be the most visible target for litigation. And even if they have you sign an indemnification clause, they're still going to be the ones targeted with a lawsuit first and have to deal with the expense and hassle of doing that. And so they try to make sure that everything, not only your script and your other film copyright issues are resolved, but that any clearances are resolved as well.
Yeah.
I don't know how much like locations play into that, if they want to make sure that you have a location agreement because maybe they'll get sued for trespassing later. But
yeah, they will require your location agreements, especially if it's a very distinctive kind of place. And then the other big thing that I find with, first time filmmakers who haven't gone through the dealing with distributors before has to do with trademarks. And when people are filming on a location and they're leaving product names and so forth in the film, and then when the distributor and their lawyers or whoever clears it on their end goes through it, it's like, well, you have this Coca-Cola can clearly here, you have this and this and this. And even though most of those, or like a business sign, and even though what I found is that the business owners or the owners of these products probably won't do anything. I mean, unless you're degrading their product in some kind of way. They probably like it because they're getting publicity out of it. But the problem is the distributors, they see it as a liability. So when I'm working with filmmakers, and oftentimes I'm on the set working with them, and I'll be looking at things, and it's like, just take that one bottle and just, is it really that important to be there? Just move it off the table. Just move it away, unless it has some real particular reason for being in that scene, in which case you should be asking for a clearance from the company to use it. Just take it away, because the audience is probably not going to really care whether or not you had a Coke can on that kitchen table or not. But trademarks is really important. It's something that really can cause problems, not just with the distributors, but then when you go to get your E&O insurance.
Yeah.
right.
And the E&O insurance company goes through your movie, and they're like picking out all of these different things, potential liability, and it makes your rate go up.
I'm forgetting the terminology, but if you film in a grocery store and there's obviously buku brands that are inside this grocery store, but nothing is prominently figured in the film nor used as a piece of the film. So in other words, if you have some product that you've created as a prop that you have a character walk up to and pay for at a cash register, it's my understanding, and please correct me if I'm wrong, that all of the branding that's at the grocery store is a part of the grocery store, and therefore I don't need to go get 100 contracts from the 100 different brands that are there, because isn't there some...
What you're speaking of is going to be some version of what's called fair use.
Fair use, thank you. I knew I...
One of my questions, thank you.
But what I always, and if you are predominantly showing a product, even though you're in that grocery store, I don't know if fair use is going to save you on that one, but fair use is such a subjective thing. Again, it's a case-by-case thing decided. I always recommend don't ever rely on fair use.
Got you.
You use it when you find yourself in a jam and something was in a scene and you didn't realize it, and now there's a problem, and then but you can't remove it from the movie. So then you use fair use as a defense.
Right. Procedurally, fair use is always a defense. You can never proactively assert fair use and say, okay, we're going to establish that we're in the clear right now because we say fair use. You usually have to get sued first before you're really given an opportunity to bring up fair use.
So, and I've had filmmakers on set, I suggested that they make some changes on the set, and they're like, well, isn't that fair use? Because this is a product that's normally used in everyday life. And it's like, you may have an argument for that down the road, but why even take that chance? It's not worth it now. Just remove it. And it's not going to make any real difference to the scene by having this trademark predominantly showing up in your film.
Now, that's a little bit different, though, with documentaries, though, and some of the archival footage.
Different.
Yes. And some things, interviews that you find in the archives or on television, as long as it's a certain smidgen, and that's a little different.
And I'm referring to narrative feature films.
I understood that.
In documentaries, it's much different. You have much more leeway because it has more of a newsworthy nature to the documentary as opposed to a commercial narrative movie, which is basically being made for money.
There's also this
So
might,
documentaries aren't made for money? I'm just joking.
Well, they are, but they have a certain newsworthy
They
element.
do.
to it.
I absolutely agree. I
And-
just wanted to poke a little fun. Sorry.
and this might be getting a little bit too much into some legal details, but the concept of fair use exists for both copyright and for trademark. And the way that courts have sort of shaped the parameters of the fair use doctrine are different depending on whether you're talking about a copyrighted work or a trademark protected brand. The copyright fair use doctrine deals with situations where you have like a little snippet of a TV show on a screen when you do a pan around a character's living room or something as someone's watching TV, or you have a few pages from a book, featured in a close-up or something like that. That's where you're dealing with copyrighted material belonging to somebody else being brought into the film. But then when you have brands, you're in the world of trademark, and judges have created kind of a different sort of set of factors for what is fair use and what's not. So I guess we don't have to get into all the specifics of that, but one thing that I actually looked into just not that long ago when it comes to trademark fair use is one of the forms of trademark fair use is what they call nominative fair use, where if all you're doing is mentioning a brand name the way you would in ordinary life, and it's just sort of as a way of identifying the product, and that's pretty much all you're doing, then usually you're pretty much okay in that sense. Like, if you have a character in a narrative feature film who's very, fashion conscious and always has really nice stuff, well, if you're making the film, your props department is probably not sophisticated enough to like also be fashion designers and come up with all their own unique designs and bags and accessories and all of that. So on some level, you do have to use actual things from the marketplace to sort of tell the story about that character that you want to tell. And so if a brand is featured, in that scenario, you probably have a good amount of leeway when it comes to the nominative fair use. Generally, I would say that fair use when it comes to copyrighted material is a lot more difficult to establish because there's a lot more factors involved, and courts have a more detailed test that they apply when they're determining whether something is a fair use.
When I'm watching a narrative film, a big budget film, and I see all these Coca-Cola cans or Pepsi, I'm thinking, they paid some money to have their products in the film.
Right.
So what we should do is the next time we have a film project, approach a company and ask if they'll pay for product placement.
Might be a good way to cover that legal line item in your budget.
There you go. Hey, I think you have an important one here. What about investors and funding? Let's talk just a little bit about that since we have a little bit more time. If we've written a script together, we've decided we want to go on. We, as in me and my partner, decided to go on this venture of creating this wonderful piece of artwork visually, and we decide we obviously want to raise some money in doing it. And so engaging investors obviously is a bigger deal. And I would hope anybody would hire a lawyer before any of that happens because, there's quite a bit of paperwork and legalese that goes into that. What are some of the pitfalls, if you will, I would ask, what's some of the mistakes you've seen or some of the things that you recommend as you move into that category, if you will, of raising money and taking money from people for your project?
Well, the first and most important thing that you need to realize when you're dealing with investors is that when you ask someone to invest in a movie, this is where they potentially could lose their investment. It is a security. It's well established in the law whether they're buying stock in your LLC that's going to, or a position, a membership position in your LLC, or whether it's just from an investor contract. It is a, quote, security, which is regulated by the Security and Exchange Commission. In the independent world, we fall under an exception. And I'm not going to get into all of the details with it. It's called Regulation D, where, what I'm getting at is that your offering that you're making is usually on big major investments, not just film. It has to be approved by the Security and Exchange Commission to make sure that you're not defrauding the public, okay? But when you have 35, I think, investors or less, And if all of your investors qualify as what's known as
high net worth individuals?
Yeah, the term is slipping my mind, but there's a definition, an accredited investor.
Accredited investor.
There's a definition. It's like a person that has a net worth of over $1 million, not including their home, or the other one is I think they have an annual salary of $300,000 or more. If that person is an accredited investor, and that's the only people you're approaching, then you don't have to deal with the SEC. So I get so many people who come to me and they want to go asking for money, and you have to be aware of this, because if you approach non-accredited investors and you violate some of these rules, and we could talk about this a while because you get into the crowdfunding and all that stuff, there's special rules dealing with that. But, that investor, if they were to lose their money down the road, they might be able to come back against you because you didn't follow the certain rules. So it's really important to at least talk to an attorney about that, to make sure that what you're going to be presenting to people fits the exception of what it is that you're doing.
It's highly important information. Anything you want to add to that? Because, I would never go and take anybody's money without a lawyer in my
I guess, so what Murray brought up is that when you get into investment, you start dealing with a totally different area of law. So, you have basic contract law, you have LLCs and some state laws involving that. You have copyright. Securities law is a whole separate area. And frankly, I don't actually have a whole lot of experience in that area, but something kind of back to the contracts and LLC component of the investment process is that often what you're offering to your investors is equity in your company, or in other words, a piece of ownership in that company. And so this goes back to a point Murray made early on where he was saying that, the formation of the LLC doesn't necessarily have to be at the very beginning. One of the reasons for that is as you bring investors on, they may become members of your LLC, in which case if you already had an LLC, you might have to adopt a new operating agreement to acknowledge the changed membership structure of the LLC. You may also have to make additional filings with the Louisiana Secretary of State or the Secretary of State in whichever state your production is based to add that additional member. It can get a lot more complicated when you start talking about, treating your investors as silent partners rather than active, producing partners of the film. And you can issue different classes of shares in the LLC. So some shares are voting shares and some shares aren't. And there's a lot of different ways that you can set that up. And so you have the securities regulations to think about, but then you also have these structural considerations of the production company or of the film LLC. And it's always very important to have a contract with your investors, acknowledging their investment, their rate of return, when they're going to start being paid back, where they fall in line in terms of priority of getting paid back. And so there's a lot of issues on that end as well to think about.
On practically every feature-length film, you're going to start a new LLC that is going to own that film, and that's all it owns. And one of the structural, you're going to need that in order to apply for your tax credits too. One of the structures would be that your investors will become members of that LLC, and you, the producer, and it could be you individually, or it could be your LLC production company, that it becomes a member of that LLC also. And it's usually set up where the producer is also the manager of the LLC and controls it. But it's all based on how much leverage you have with the investors, because they're going to have their lawyers involved. Okay. And they're going to want to make sure that they're protected, so it's true. It's a whole different world when you're dealing with the investors. But there are some circumstances, and I've worked on films where the investors did not want to be a member of the LLC. That obviously gives them more protection and control. So if you're dealing with a multi-million-dollar project, those investors are probably going to want to be members, and they're probably going to have their own LLC set up to be the member of the LLC that's going to own the movie. But on smaller productions, some high net worth individuals don't necessarily want their name on the company, and they would rather just put up a certain amount of money and just get a contract back as to what it is that they're going to be entitled to. So you can go different ways, but it all depends on the investors you're dealing with and how basically they want to set it up, because the filmmaker's basically at their mercy.
Absolutely, man.
Yeah,
I feel
one of the things investors are going to ask for is your budget, and they might even want to read the script. So they'll have a very good idea of all the inner workings of your film. And if they, let's say you have just to have this numbers, say you have a small budget, $100,000 film, and you have an investor who's willing to put up $70,000, $80,000. Well, right off the bat, they know that they have a huge amount of leverage there because they're going to be the primary funder. And that's where they can really call a lot of those shots. So, there's part of that negotiation is going to be the investors doing their due diligence. They want to make sure. They might even look at chain of title issues as well, depending on how far along you are. And they might want to know, hey, is this going to be a project that's actually going to go somewhere and won't get derailed by litigation? Or, am I investing in something that really where I could really see a return on that investment?
I mean, so much information to take in. I think we've been doing this for an hour, and I feel like we could do another 10 hours just on the legal.
And of course, you know me, I always have one more question.
Please give it.
I want to go back to music for a moment. And I'll use myself as an example because I was not aware of this. And that's why music is so much different. You alluded to that earlier, Max. You hire a composer. I hired my composer who wrote a score for the film. And I also, a person that wrote a couple of songs, they were her songs. I re-recorded them for my movie where, in my mind, I own the recording, and yet she owns the song. So it's a lot more than just having a contract for work for hire. Regarding the musicians, you have to have releases.
Right.
What else do you need? Because it's not just because you hired and you own the score. It's a lot more than that. Please talk to us about that.
Okay, so let's get one basic component covered first, which you alluded to, which is when it comes to recorded music, you have two copyrights to think about. You have the sound recording, which is the actual sounds that you hear, and then you have the musical composition. So the chord progression, the melody, the lyrics, all of that is covered by the musical composition copyright. So whoever wrote the song, whether or not they're also the recording artist, doesn't matter. But if they wrote the song, then they are likely going to be the owner of the musical composition copyright. And then when you go into the studio, whoever records that version of the song is likely going to be either the owner or a co-owner of that sound recording copyright. So when you have music that already exists, it's actually relatively straightforward because you just have to go find out who's the owner of the musical composition copyright, who's the owner of the sound recording copyright. You go contact each of them. You say, I want to use a 10-second clip of this song in my film. It's going to appear in this scene. Here's what's happening on screen while the music plays. What is your price? And with the music on the musical composition side, you would get a license agreement in place known as a synchronization license. And then with the sound recording, you would go through the same process, but usually with a different entity, because frequently, especially when we're talking about commercial music, you have music publishers who own the composition copyrights and record labels who own the sound recording copyrights. And you go through that same negotiation process with the owner of the sound recording, and you get a license agreement in place known as a master use license. And both of those are just basic copyright license agreements. So there will be some duration of the license, whether it's exclusive or non-exclusive. There will be a fee. The sort of benchmark for sync licenses is around $5,000 for major commercially released music, especially if it's a relatively big budget film. Though sometimes you can ask for festival-only licenses that are only good for a year, where the license terminates if you get distribution and you have to renegotiate. Those often can be a lot cheaper. Now, when you are then hiring somebody to create music for the film, remember I mentioned earlier that music doesn't technically fall into the work for hire doctrine, even though the entire music and film industry sort of treats it like it does. And so you often may have a contract that has that work made for hire language in there, but you also, and this is something I recommend all the time, is you include additional language of assignment. So in case a judge looks at this and realizes work for hire doesn't apply, you're still selling your copyright to us anyway. So that's sort of addresses your composer situation, is you mostly just have to have a single contract in place with that person that recognizes this person's being hired for this particular thing. This is what I'm going to pay him. And then he's going to assign his copyright over to me so that I own it. And it goes to the chain of title issues as well. Not necessarily as crucial as the script, but if you have a score for the entire film, you don't want the film to then be sort of awkwardly silent in weird places because you didn't get the score properly documented. If you have somebody who has songs that already exist and you recorded them yourself, that's an interesting situation where you don't actually have to get permission to use the sound recording. So you don't have to get a master use license, but you do still have to get a synchronization license for the musical composition. So if the song already exists and has already been written, you'll need to have that sync license. That's the shorthand term we use for it, with whoever the songwriter is, or if they have a publisher, usually you'd be talking to the publisher to clear those rights. Does that answer your question? Because there's a lot of other things with music.
All the more reason why you need to hire a lawyer.
Absolutely. There is no reason why someone shouldn't hire a lawyer, whether it's music, whether it's film, whether it's writing a script, regardless of what role you play. I wouldn't work on a film without a contract, period. And I may do it as a favor, but once I get in my car and drive to a location or assist in a meeting, I want a contract. But even though you have a contract and it's an LLC, it doesn't mean that you'll get paid necessarily. But I demand a contract. I've learned a lot.
Yeah, I recommend, obviously, talk to somebody of legal profession before you get these things started. Don't be afraid of the costs that are involved. Just start with the informative nature of contacting somebody and find out, one, if you can afford it, and two, if you can't afford that number, if there's somebody that'll work with you on it. I know in many cases, and I've had one personally where I had a lawyer partner with me. I couldn't afford the entire, thing. So I gave up a piece of it. He believed in the project and we moved forward. There are those opportunities in some cases. So just talk to legal representation. And speaking of, go ahead.
I was just going to add something to that. One thing that's been really exciting and encouraging that I've noticed over the past few years is there finally seems to be some growth in this area. There's quite a few young attorneys who are coming out of law school in the past couple of years who want to stay in the New Orleans area and work in the entertainment field, which I mean, even just 4 years ago when I was graduating, I didn't know of very many other people who were doing that. But just in the past 6 months, I've met 2 or 3 people who've only graduated in the past 2 years or so who are really interested in it. So I think that there's going to be more options available locally. And another thing to think about is that not every aspect of your film is going to involve federal law, but copyright and trademark are areas of federal law that are pretty much the same everywhere you go in the United States. And a lot of the basic considerations of film are also pretty similar, though you do have different state law issues when it comes to contracts and LLCs. You may be able to find assistance from attorneys in other markets as well, or at a minimum, ask them some questions about copyright, because no matter where they are, they can probably help answer those questions.
Good point, except for the unique nature of Louisiana Napoleonic law, which is
right.
something completely interesting. But
right, when you get into
unique.
Contract law and locations agreements where you're dealing with real estate, that's where uniform. State law becomes a lot more important.
Gotcha. Well, how can we have folks reach out to you all? Murray, how can they come find you if they need us?
They can just find me via my website. There's a contact page. The website is www.murrayroth.com, which is MURRAYROTH.com. And just send me a message. It goes straight to my email.
Fantastic. And
I also have a website. It's a little bit longer. It's my firm is called Action Potential Entertainment, and the website is actionpotentialent.com, as in the first 3 letters of entertainment. And I have my bio, contact form, email address, phone number, all of that up there as well. You can also find, I don't know if Murray, you're on like any of the lawyer directories, but if you search entertainment lawyers on avo.com or Justia or some of those other sites, like I said at the beginning, there aren't that many entertainment lawyers in this area, so you're likely to find probably both of us if you search for entertainment lawyers on those directories. So that might be another way people can find us.
So before you go make movie magic, call these guys and get the magic language to make sure that it's all set up properly, is I think what we've learned today.
I think this is one of the most important podcasts that we have done to date. Mm-hmm. I mean, yes, we talk about getting a job. We talk about producing, directing, but you've got to have the basics, the contracts, the lawyers, the legal terminology. Mm-hmm. That is truly movie magic.
So
it's a business unto itself, and most businesses that are not in the entertainment world are using contracts and making sure that they have all their I's dotted and T's crossed. So it's the same concept in film.
Well, thank y'all so much for being here today. We really appreciate it. It sounds like we need to have you back again in the future to take another hour to continue this conversation, because I feel like we just broke the seal of what needs to be discussed.
Yeah.
So thank you again.
Of course. Thank you.
Thank you.
Thanks for listening to this episode of On the Neutral Ground.
It's been a great show. Now be sure to stay connected with us on social media at On the NG Show. We'd love to hear what you have to say.
And special thanks to our audio engineer, Tijan Dabaziz, and videographer and editor, Andre LaFleur.
Thank you for listening. We'll see you next time.